events happened. Events happened prior to October the 23rd. Events happened on October the 23rd in this courtroom that had to do over the period of about an hour. That was basically a mini trial where Mr. Samuels and I were put on trial here in what I call an ambush, where we were led into the culmination of me being charged with felonies for practicing law without an attorney that had absolutely nothing to do with the questions at hand in this public records case. And my position is that was premeditated, and that came all the way back to that box I was talking about. That box of secrets, that information that these plaintiffs, that are mainly public officials that had relatives working, that got money from the other side of $7 million from the other side, these grant recipients. These two sides, these lawyers, these teams of lawyers were told to gang up and try to stop this. Try to stop, keep that box from being opened up. And that happened on October the 23rd. And they did that on that day. And you saw that. So, and your ruling was spirit and intent of the law. I thought it was over. I thought it was a dirty trick, but whatever. So after that, and Your Honor, you know this. I know you know this. After that day on October the 23rd, there were two separate other movements that happened, where they were movements to have me indicted for felony counts and an arrest. And I came this close, within hours, even less, to being arrested and put in jail, have my freedom taken away, have a mugshot, and spend time in jail, and then be fighting for my freedom. My point is, things happened that day and after that day. Personal attacks against me to try to have me removed from this case. And because of that, because I was a citizen, because I asked for public records, because I was named as a defendant in this suit for reasons I have no idea, because on June the 24th, I said I could not go further in this case. I needed to seek counsel, and that was ignored. Separate to that, I asked for the plaintiff to pay for that counsel. That was denied. Those are two separate requests. I soldiered on, and then I find myself here on October the 23rd, completely surprised and ambushed, thinking that we're going to proceed toward the question at hand. And then even after that, I came within that close, had it not been for the proper actions of the good people of being arrested. And I cannot go 1 minute longer as a pro se defendant. That's my position. There's two separate motions. And I have to seek counsel. The last portion of that motion is because it is not a 86 question. It has nothing to do with if I was denied counsel before or not. It doesn't matter how old these various items are or not. It has nothing to do with that. It has everything to do with I was targeted because parties here they're desperate. I know that people may know that Mr. Lambert put in writing a couple of weeks ago. He warned the citizens that they are playing a very high-stakes game in writing. It's true. This is a very high-stakes game to keep that information buried. So that happened to me. The things I'm telling you, and this is going to be investigated. And this is not the end of this. And I'm telling this court, I can't, that's why I was sitting there. I can't stand here and pretend that I can represent my interests and the people's interests, knowing that when I walk out of here, I don't know what's going to happen to me. I came that close to missing the birth of my twin grandchildren.
Practicing law and as a judge for 37 years, that judges want to hear as much informed comment on the issue at the matter at issue that is helpful in making a decision. As a personal matter, would it be helpful to any trial judge to hear or have legal briefing from a pro se party? The answer is an obvious yes, but mere convenience or even advantageous convenience is not the legal standard, even under an apparent authority analysis, when the statutory and case law, the statutes and case law that speak to it are what they are. And I'm obligated to follow along. Your attorney, if you choose to speak to one, your attorney will have the opportunity to review what we've said, what's been argued in this hearing, and basically you have the chance within 20 days for an attorney to file a notice of appearance and to file what he or she evaluates in his or her own professional evaluation to be in terms of motion, a document, a pleading, or other matter. So an order in this case would not be entered, probably would not have intended to be entered probably within that period. And so I don't view it as a delay of this hearing, which has been scheduled for months. It also gives you, after the hearing, with the arguments fully blown and discussed, if you consult with counsel, it gives your attorney a chance to evaluate and comment and give you legal advice. And that's the next best thing to having a brief from your attorney or a memorandum, like I do with CareSync and IDA. But if you've got the benefit of that and your attorney has the benefit of giving you advice on it, I think that is a very good thing to do, and it does not unreasonably, unnecessarily delay of reaching a decision in this case, depending upon the response. I cannot say what a judicial response would be based upon what your attorney may file, because that hasn't happened, but it would put you in a position of having legal advice, and that's a good thing. That's a good thing for any party in any case, and by extension, any party in any case having legal advice is almost always to the benefit of the judge presiding, because the parties informed on technical legal matters. Any follow-up, sir?
Sir, I think that's a good decision. I appreciate it.